So the Supreme Court just denied emergency review in a case which was seeking an immediate block of New York's controversial rifle and shotgun permit requirements. So let's talk about what just happened and where this case goes from here. But really quick before we jump into this video, if you think it's time for the Supreme Court to start taking up more 2A cases, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are huge Second Amendment supporters. They have dedicated roasts for organizations like FBC, GOA, and SAF. So if you want to get amazing coffee and support a coffee company that actually supports the Second Amendment, check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be discussing a new case which is seeking immediate Supreme Court intervention and which was just denied review. The case we're going to be talking about in this video is called Schrower versus the City of New York. This case involves a challenge to New York's application process that essentially requires residents of that city to first apply for a permit to be able to acquire rifles and shotguns within the city. One of the major issues with the permit requirement is the fact that it is purely discretionary. That means that the police department there in the city of New York gets to determine who can legally possess and acquire these types of firearms. That police department gets to determine who meets the good moral character determination and who does not. Essentially, they get to determine who has good enough character to exercise their Second Amendment rights. Now, this case involves a permit scheme that in some ways is in direct defiance to what the Supreme Court recently ruled in the New York State Rifle and Pistol Association versus Bruin case. The plaintiffs argue that under Bruin, the Supreme Court struck down a similar application process that was purely discretionary. The Supreme Court found in that Bruin case that there was no historical support for a May issue CCW licensing permit scheme, and now the plaintiffs in this case argue that there is no historical support for a May issue firearms possession permit which is going on in the city. This entire lawsuit sprung up because of the Supreme Court issuing that Bruin decision. In Bruin, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. Now, one of the primary findings of the Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. In Bruin, Justice Thomas, writing for the majority, stated that New York's proper cause standard was in fact invalid. He went on to state that the burden falls on the respondents to show that New York's proper cause requirement is consistent with the nation's historical tradition of firearms regulation. Only if respondents carry that burden can they show that the pre-existing right codified in the Second Amendment and made applicable to the states through the 14th does not protect petitioners' proposed course of conduct. So that's kind of the backdrop of the Bruin decision, rejecting the use of the proper cause standard and similar good moral character standards, and essentially the granting or denying of concealed carry permits based on those discretionary standards. And in this case, the plaintiffs are using that Bruin decision to attack a good moral character requirement that is now being used to approve or deny permits, essentially to own, possess, or acquire these types of firearms. Now, this case was brought by the plaintiff Joseph Schrower, who challenges the constitutionality of New York City's discretionary licensing scheme for the purchase and possession of rifles and shotguns. Now, on review, the district court, the federal court there, granted a permanent injunction against a provision of that scheme that essentially required individuals to prove that they are of good moral character, essentially having to prove that before they're allowed to purchase or possess firearms. That, of course, was a huge win because you had a lower court, a federal court, finding that this type of permit scheme and the good moral character standard was improper. But of course, the city of New York was not going to let that stand, so they quickly filed an appeal up to the Second Circuit, and the Second Circuit is not good for us when it comes to the Second Amendment. New York also sought a stay to be put on that permanent injunction while the case is being appealed in the Second Circuit. The Second Circuit, of course, granted that stay in favor of the city of New York. This emergency application that was filed to the Supreme Court asking for the Supreme Court to step in early on an emergency basis was essentially for them to remove that Second Circuit stay that was issued by the Second Circuit. Now, the two main arguments being presented to the Supreme Court on why they should remove this stay was essentially that the city of New York will not win their appeal. The argument was that the lower court already ruled in favor of the people here as far as the Second Amendment, finding that the good moral character standard violated Bruin, violates the Second Amendment, and that the city of New York on appeal is still going to lose, and therefore the Supreme Court should step in now and remove the stay that was put in place by the Second Circuit. Also, there's an argument that the Second Circuit is relying on the CCIA's anti-nuke case, which involves concealed carry handgun licenses, but that is incorrect. Here, they're pointing to the fact that anti-nuke is not binding on appeal specifically on this issue because anti-nuke dealt with a preliminary injunction and not a merits-based determination like is happening here in the Schroer case. Schroer's in that appeal here is actually a merits review. It's an actual merits appeal. Anti-nuke is still in an interlocutory posture. It's still dealing with a preliminary injunction. Now, one of the also interesting things with this decision and the using of anti-nuke here in the Schroer case, because the Second Circuit said that Bruin was an exceptional case and that anti-nuke is not, and some of these other cases now, like the Schroer case, are also not exceptional. So the court here, the Second Circuit, does not have to follow what the Supreme Court said in Bruin. So that's one of those very interesting things that developed in anti-nuke. And so they're arguing here that the Second Circuit relying on anti-nuke again is still a failure. It's still incorrect. It's an error. And, this type of precedent should not be used in this case, and that the Supreme Court should step in now and put a stop to this type of defiance. This emergency application was originally filed to Sonia Sotomayor, who is the justice responsible for reviewing emergency filings that come out of the Second Circuit. Now, back on April 4th, Justice Sotomayor denied the emergency application on her own. She did not submit it to a full court for consideration. She just denied it on her own. Now, usually what happens with these types of emergency applications is the justice responsible for that area will in fact just submit it to the full court for consideration, but she denied it on her own. But what that meant under the Supreme Court's rules is that the plaintiffs here, Justice Schroer, could then go to any of the justices that he wanted and submit a new renewal, application for consideration, and that's exactly what he did. And what ended up happening is that Justice Thomas accepted the application and then referred it to a full court conference and consideration back on May 16th. So then after May 16th, which was last week, we were waiting to see what would happen. Now, this Schroer case went to the Supreme Court for conference with a bunch of other, Second Amendment cases like the Bianchi Maryland assault weapon ban case, and then also the Illinois rifle ban cases that also went for that same conference. And then we were waiting to see what happened. And this week we got an order list from the Supreme Court. And unfortunately, they denied emergency review in this case, Schroer, and then also the Bianchi case. Now, you may be asking yourself, okay, what does this mean and where does this leave us? Is this case dead in the water now that the Supreme Court has denied the emergency application? And the answer to that is no. First, keep in mind that the Supreme Court does not traditionally like reviewing these type of cases, especially when they are seeking, simply a reversal of a stay order. These are, kind of these weird emergency applications that the Supreme Court does not like to actually review. They like final merits reviews. They like circuit court splits, and that's traditionally when they will review cases. Here, you had this, in-between stay order that was issued by the Second Circuit, and the Second Circuit is still right now going to actually review this appeal and then issue their own merits determination. So the Supreme Court likely said, we're not going to get involved right now. We're going to let the Second Circuit issue their own merits decision, and then we will reconsider this case at that time. So as you can see, there's still a lot of development left in this case, and that's probably why the Supreme Court decided to just simply punt on this issue right now. Now, another thing to keep in mind and to consider is the fact that currently right now, we're waiting for a new Supreme Court decision as far as the Second Amendment, and that's an opinion in the Rahimi case. We are waiting for a decision in Rahimi. That case there is actually seeking an application of Bruin to a federal law, and the application of Bruin to that specific federal law, which is the domestic violence restraining orders under federal law, that has huge implications for a lot of other 2A cases. So maybe the Supreme Court's current mindset is that they're simply going to punt all of these cases, right now, wait for the Rahimi decision, and then see where the chips fall after that. Let the lower courts apply Rahimi instead of, stepping in now before Rahimi and then have to see, all the weirdness that happens after that. Instead, they're just going to issue their decision Rahimi and then see how the courts deal with it after. So again, not great news, but this case is not dead in the water. Now we're just going to have to wait to see how the Second Circuit rules. If we get any more information, I will let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.